Welcome once again. My name's Claire Giles. I'm the Head of Compulsory Purchase at Homes England, and I'm supporting our local government capacity centre today. I'm delighted that we're able to bring you our winter learning programme. And the programme offers a series of sort of knowledge sharing sessions on topics that you've told us before that you are interested in. And today's event is on the subject of local land assembly using compulsory purchase powers. Next slide, please. So just as a bit of background, I'm not going to read this, but this states what our local government capacity centre is all about and what we do. And we launched the centre after extensive research and consultation with across local government and other partners to sort of ascertain where we thought you might need support and how we could do this and how we could deliver this to you. And we look forward to hearing from you how you think the winter programme has gone as well. Next slide, please. So this is just a quick breakdown of why we're here today. So why are we talking about land assembly using compulsory purchase powers? Well, I think it's clear that they can be a key part to delivering development and placemaking. And so today we're going to be running through whose powers are most appropriate to use, and also some of the compulsory purchase processes, and also perhaps some of the tips and tricks and some of the recent decisions and how they may impact on compulsory purchases that you may be undertaking. And what we're hoping is that by the end of the session, you should have more confidence in considering the use of compulsory purchase powers for your schemes that you are looking at. So I'm now going to hand over to our two speakers today. So we're very pleased to have with us from Carter Jonas two experts in the field, Paul Astbury and Michael Walton. And I'll hand over to Mike and Paul to do their own presentations.
Thanks very much, Claire. Welcome, everybody. Yes, as Claire said, land assembly is an integral part of what we do in terms of regeneration, placemaking, improving our environment. We have to have the land and able to do that. Land assembly doesn't necessarily mean compulsory purchase, but having compulsory purchase tools in our toolbox and knowing how to use them is very valuable. My name's Paul Astbury. I'm a partner at Carter Jonas. I run the infrastructures team in our London office, and I've had specialised in compulsory purchase for about 30 years. 15 years of that was at Transport for London in-house, dealing with schemes such as Crossrail, Jubilee Line Extension, Docklands Light Railway, and many others. Since leaving TfL and entering the private sector, I've advised on High Speed 1, High Speed 2, and compulsory purchase regeneration orders around the country, mostly in London, but also in Birmingham and Canterbury as well. Mike Walton is joining us as well. So Mike and I will be sharing this. We're doing a sort of tag team approach. Mike's also a partner in Carter Jonas and also in the infrastructures team in London. I'll let Mike introduce himself more fully in a second when he starts his portion of the slides. Well, as I said, what we're trying to achieve today is land assembly, understanding land assembly's importance in delivering projects and delivering regeneration, housing, infrastructure, whatever it might be, but also with a focus on the use of compulsory purchase powers where appropriate. Now, they won't be appropriate or necessary in every instance, and in fact, we'd like to think that we can get our land assembly done if possible without using compulsory purchase and just negotiating by agreement, and that's our ideal situation. But in a lot of cases, you'll find that having a compulsory purchase strategy, at least, is going to be very useful in terms of a backstop, so that if the negotiations don't go the way we hope, then we do have an alternative to secure the land that we require and move the project forward. There are lead times, obviously, in compulsory purchase, so the important thing is to understand what you need to do, when you need to do it, and also make sure that even if you're not planning on using compulsory purchase powers, at least your land assembly actions and strategies are compatible with using them later on, should the need arise. So, Mike, if you'd just like to take on the baton, so to speak, and talk to us about land assembly's importance within project delivery.
Yeah, so I'm Michael Walton. I'm a chartered planning and development surveyor by background. I've got private and public sector experience in the UK mainly, but also in Australia. and had sort of different perspectives on land assembly from different types of organisations. But the thing which I suppose is a common theme to land assembly is that any project which needs land, well, without that land, there probably isn't a project beyond a series of pictures and plans. That land is a key element of delivering any major infrastructure or regeneration scheme. But delivering that land requirement is also a key part of a much more comprehensive project program. So this bubble diagram here is really supposed to show in a slightly more interesting fashion than Microsoft projects how land assembly fits into all these different overlapping work streams, and is not something to be forgotten. It's something to be woven into that wider project. So if we jump onto the next slide, please. I'd just like to think about how, or specifically what types of project need land. And this is something I call the intervention matrix, and it really sets out how the complexity of a project and the scale of the intervention necessary is really proportionate to the scale of the failings in the urban environment, if we're talking about a regeneration scheme. So if we're talking about somewhere where the urban fabric broadly works but is a bit shabby, let's imagine Camden 30 years ago, then you're probably looking more at public realm, community activation and that sort of thing. So if we jump onto the next slide, I've sort of pasted over this what that means in terms of land. You know, that first example, you probably don't really need a lot of land. It's probably mainly within the highway. But when you get to the point of much more significant interventions, so if we look at the one where there's fundamental failings in the urban environment, let's imagine a 1960s housing estate, you're going to need a significant level of intervention, and you're going to need a significant level of land assembly. Or even if there's no urban fabric, a greenfield urban extension or a new settlement, you will need land assembly. Maybe that there's one landowner and they'll work with the local authority. Maybe they don't, but you need a strategy which is really proportionate to the level of need for land and the challenges in assembling that land. So if we jump onto the next slide, then this building, I suppose, is supposed to represent the one building that stood there, that's left. The one thing that we've heard countless times of, you know, we only needed one property, or we've acquired everything but property, that one property. And of course, the standard response of we're not selling, that it's not just assembling some of the land, it's getting all of that land together to deliver the project, which is key. And thinking about that at the very beginning is fundamental to making sure that that project program isn't delayed because of the land requirements. So I'll hand back to Paul on that note.
Thanks, Mike. Go to the next slide, please. So Mike's outlined how important land assembly is and the various degrees of land assembly we might come across when we're dealing with a project or hoping to bring a project forward. I'd like to just have a quick look at when we might use compulsory purchase powers, because what I think most people would think of in a compulsory purchase situation will be a large scale scheme where you're assembling a major site with lots and lots of interests, and you need a compulsory purchase order to get it all done. Now that's obviously a very strong case for a compulsory purchase order. As an example there at Brent Cross, 150 hectares scheme in North London. That actually took, I think, 3 CPOs to get that done. But also we see this in housing estate renewal projects as well, where you might have dozens, if not hundreds, of leasehold interests to buy back in. And also other, obviously, the larger infrastructure schemes, high speed ones, high speed twos, where you've got literally thousands and thousands of interests to bring in. But of course, compulsory purchase can also be of great benefit where we don't have a huge scheme that we need to get lots and lots of pieces of land assembled. It can also be very effective where you have maybe a small number, but the critical acquisitions which need to be secured in order to allow this scheme to move forward. An example we dealt with is Slatter's Hotel site in Canterbury. It was a city centre site. It was a former hotel. It had been derelict for about a decade. The council had finally managed to get someone to take it on, a developer, to bring forward a development, another hotel, and obviously to mend the streetscape and also contribute to the environmental and economic and social well-being of the city. In order to bring this scheme forward, the council owned the main site, but they needed an extra 2 meters of land in the neighbouring shopping centre's car park and some rights over their service centre, a service yard rather. It was necessary for us to pursue a CPO because negotiations had broken down and obviously weren't going to give us the result we wanted. As it turned out, we got to the inquiry, and at the very end, the adjoining landowners did do a deal, and they did manage to secure, the council did manage to secure the property that they acquired by agreement. But the benefit of the compulsory purchase order was that it drove that process, set deadlines, and stopped it drifting, it gave us an end point. Have the next slide, please. Another area you might use compulsory purchase powers, which might not be particularly obvious, is where we're cleaning titles, so to speak. An example of that is Sugarhouse Island on Stratford High Street, again in London. This was Newham Council partnered with a developer, and the site was almost entirely acquired by the developer by the time of the compulsory purchase order. There was only 3 small sites remaining, and I think there was only really 1 by the time we actually got to the inquiry. But the CPO was sought over all of the land, including the land that the developer had already assembled, because it was a site steeped in history, lots of different land ownerships over the years, lots of different rights and covenants and all sorts. So it was a complicated land ownership history to the site, and it made it just as a safety net to ensure that if anything did come out of the woodwork, we'd be able to deal with it promptly and clean the title of any issues. We also came across something very similar on High Speed 1, where we were advising on a section out in Dagenham, East London, where again it was an industrial area. It's where the old Ford manufacturing plant was, but lots of other industrial sites down there. And the land titles and land registry titles are all variously based on OS bases ranging back from the 1920s, the 1950s, the 1960s, 1990s. And obviously, when you put those things together next to each other, they don't always join up in the way that you might think they do. And we had lots of areas where there were apparent strips of land or bits of the bottom of the site where there was no obvious owner. And the use of the compulsory purchase powers allowed all that land to be vested and brought into the ownership of High Speed 1, so there was no question over the ownership. And we also dealt with a scheme up in Northampton where a similar thing happened, where again an unknown owner owned a strip of land through the middle of the site, and the acquiring authority was able to acquire that land under the CPO and clean the title. The benefit being, of course, that if you've acquired the title under compulsory purchase, it does raise the payment of compensation, which needs to be dealt with should the owner turn up. But what the owner can't do is injunct the scheme and stop you carrying on with your development and saying, well, you're trespassing on my land in the middle of the site and you've got to stop development. And of course, they can hold a hand out for almost any amount of money they want at that stage. So the compulsory purchase of the land sets the rules for compensation. It's the no scheme rules, as we might be familiar with, but also more importantly, it means that the compensation becomes a separate conversation and doesn't hold up the progress of the scheme. And the last thing on the slide there, I mentioned appropriation. Appropriation is not, technically speaking, land assembly. It's not the acquisition of land. It's technically the change of the purpose for which land is held. But when we appropriate land under the Section 203 of the Housing and Planning Act 2016, if land has been owned or land or vested or owned by a relevant authority, which is various councils, etc., set out in the Act, then it enables development to be carried out on that land, even if that development conflicts with an existing third-party right or a restricted covenant, etc. And it does a similar thing. It changes the remedy for the person owning that right or that covenant from a right to injunct and prevent the development from going forward, and that takes that away and converts it into a right to claim compensation. So again, we have to pay compensation, which is fair, but we don't get our scheme held up. There are various caveats all around appropriation. I'm not going to get into those today, but just to give you a flavour of how you might treat third-party rights or protect yourself against them. So have the next slide, please. So who can use compulsory purchase powers? Compulsory purchase powers in the UK all emanate from Parliament one way or another. The most common way is through legislation, what we call an enabling act, which is an act of Parliament which says, amongst usually many other things, that an authority can use compulsory purchase powers for a given purpose, and it will state in the particular act what the powers that that act confers can be used for, what purposes, and also who can use those powers. And when you've got powers under those acts, you then have to obviously apply for a compulsory purchase order to be able to actually use those powers, and individual projects then apply for CPOs or compulsory purchase orders, and then these are individually examined and approved or not by the Secretary of State. On the next slide, please. So here are a few examples. The Town and Country Planning Act 1990 contains, as I said, amongst many other things, compulsory purchase powers. Those powers are available to local authorities, and it's a fairly wide-ranging power which you'll find used for a lot of regeneration schemes, and it's basically the purpose of land assembly or compulsory purchase under the 1990 Act is for facilitating development which promotes the social, economic or environmental well-being of the area. So a fairly wide definition, but very, very useful for regeneration purposes. The Housing Act 1985 is a bit more specific. That again confers powers on the housing authority for the area, and it allows land to be acquired for housing purposes which create either a qualitative or quantitative or both improvement in the housing for the area. The Housing and Regeneration Act 2008 are the Homes England specific powers. We'll have a look at those in a slide or two. And the purpose there is for the furtherance of the Homes England objects or objectives, and they can be used by Homes England. And then finally, the Local Government Miscellaneous Provisions Act 1976 is a fairly general power, and that allows a local authority to acquire land for any purpose which they are authorised to carry out. It's more commonly used for the acquisition of rights as opposed to taking land itself, and you'll quite often see it partnered with the Town and Country Planning Act 1990. Next slide, please. Just to complete the picture, here we are on infrastructure type schemes. We have DCOs or development consent orders under the Planning Act 2008. Anybody can apply for a DCO, regardless of who they are. The thing that limits it is the project. So the project that you're promoting with your DCO, development consent order, must be a nationally significant infrastructure project, and that's defined in the Planning Act 2008. Transport and Works Act orders, or TWAOs, in the Transport and Works Act 1992. Again, anybody can promote one of those. It can include CP powers, compulsory purchase powers, along with other consents, and it has to be for a scheme which fits within the definitions in the Transport and Works Act order, Transport and Works Act, and they are generally guided transport systems. And then finally, there are various powers available to utilities. We have the Gas Act, Electricity Act, Water Acts, etc. And they are providing compulsory purchase powers for the furtherance of providing that sort of infrastructure. Have the next slide, please. So to give us a little bit of guidance on how to use compulsory purchase powers, the government have issued a guidebook, effectively, compulsory purchase and the Critchell Down rules. And that sets out what the government expects acquiring authorities to do in terms of making a compelling case to authorise, to justify the use of compulsory purchase powers on their particular project, and also how they should conduct themselves in the time that's leading up to the compulsory purchase, and how they should engage. We'll look at that in a bit more detail later in the session. But in terms of the guidance in what we call Tier 2 or Section 2 of the guidance, there is bits relating to individual acts which give powers, and it gives a little bit about the specific purposes and what tests might be applied to those particular powers. So in the section under the Town and Country Planning Act 1990, we can see there that the power is intended to provide a positive tool for planning authorities to use their planning powers to assemble land where this is necessary to implement proposals in their local plan or where strong planning justifications for the use of the power exists. And also, as I said, the test in there as well is whether it facilitates development which promotes the social, economic or environmental benefit or well-being of the area. The next slide, please. Housing Act, again, as you might expect, you need to be able to bring housing forward, and we're again looking for a quantitative or qualitative housing gain, or both if we can manage it. Next slide, please. So this is the Homes England specific power, the Housing and Regeneration Act of 2008. So Homes England can use its compulsory purchase powers to make compulsory purchase order for the achievement of its objects as set out in section 2 of the Housing and Regeneration Act 2008. And those are, in short, to improve the supply and quality of housing in England, to secure the regeneration or development of land or infrastructure in England, to support in other ways the creation, regeneration or development of communities in England and their continued well-being, and to contribute to the achievement of sustainable development and good design in England. So again, very widely based powers, a bit like the Town and Country Planning Act 1990 in terms of the breadth there. The next slide, please. So we've looked at where our powers come from and what we're allowed to do with our powers, when we should use them. I'm just going to now touch on the CPO process. This is obviously very high level, just to give you an idea of the sort of thing that you have to do in order to secure compulsory purchase powers and what the process looks like. So in very high level overview, the first thing we have to do is prepare our CPO, and that means we'll set out what we want in terms of the land that we want to acquire. So there'll be what we call a CPO plan that will outline the area that we intend to use compulsory purchase powers on, it with a red line. Inside that red line, we'll break it up into plots, which will be individually numbered, and then those plots will be coloured. Either the convention is pink for land that we want to acquire outright, or blue for land over which we don't want to acquire, but we want to create a new right of way or whatever it might be over that piece of land. And then keyed to that, there'll be a schedule attached to the order, which will set out all the people who own each individual plot, a description of the plot, and who are the tenants, who are the owners, who are the occupiers of that land. So that identifies all the people who are affected by a compulsory purchase order. So that's then sealed by the acquiring authority and sent off to the Secretary of State for approval. And at the same time, we have to notify all those affected parties that we've listed out in our schedule that they are able to object to the CPO if they wish, and they will send that objection to the Secretary of State direct. The Secretary of State, if they receive objections, will require the planning inspectorate to hold an inquiry to hear those objections and also to hear the promoter's justification for the use of compulsory purchase powers. And that, I should have mentioned, that justification will be set out in some detail in a document that accompanies the compulsory purchase order called a statement of reasons. So having held the inquiry, listened to all the arguments on both sides, the inspector will then report their findings to the Secretary of State with a recommendation as to whether or not the order should be approved or confirmed. So the Secretary of State might have already delegated the power to make the decision down to the inspector, in which case the inspector will do a report and that will be there, include their decision in the report, and that will be the decision as to whether the order is confirmed or not. If the Secretary of State has not delegated that power down to the inspector, then obviously the inspector will send their report to the Secretary of State. The Secretary of State will look at the evidence, look at the report, and they will make their mind up for themselves. They may or may not follow the inspector's recommendation as to whether or not the order should be confirmed. If the order is confirmed, the inspector or the Secretary of State, whichever it is doing the confirmation, will write back to the acquiring authority and say, congratulations, your order has been confirmed. At that point, we then have to, as the acquiring authority, have to notify everybody that we notified originally to say this has happened, the order's been confirmed. There is then a 6-week legal challenge period, after which we are safe from legal challenge if no challenge is made in that period. So even if there is some legal flaw with the compulsory purchase order, no one can do anything about it, and we are safe to use our order and rely on it as we acquire land. So let's have a look at that process in a little bit more detail. The next slide, please. So we're going back to the beginning. The most important thing we have to do before we even start thinking about a compulsory purchase order is to negotiate for the land that we want for our scheme. So we need to go and approach the landowners, engage with the affected parties, the landowners, the occupiers, and negotiate, if we can, to buy the land by agreement so that we can bring our scheme forward without the use of compulsory purchase powers. If we think we do need compulsory purchase powers, we need to make a formal decision as an acquiring authority. Now that might be through cabinet or committee, but it needs to be a formal decision based on an officer's report to say these are the reasons why we think we need to use compulsory purchase powers. This is a justification, and please can we have permission to go away and do our compulsory purchase, at which point the council will then usually delegate power to officers if the resolution is passed to actually go ahead and then start drafting the order and implement it. So the first thing we do as part of our drafting of a compulsory purchase order, alongside of our negotiations and getting our permission and our formal resolution, is to do what we call formal title research or land referencing. This is where we do desktop surveys and also contacting potential landowners and visiting premises, sending letters to work out exactly who owns all the land, who are all the occupiers, who are all the affected parties, so that we can populate our CPO schedule. So that's our land referencing stage. So when we've done our land referencing, we're then able to draft up our order, prepare our schedule, prepare our plan, prepare our statement of reasons, get it all sealed, signed and delivered, send it off to the Secretary of State to be approved. And at that point, we then write everybody and say, we've made this CPO, we've applied for the CPO. You've got a right to object. It's either 21 or 28 days, it's usually 28. And you've got that amount of time in order to object to the Secretary of State. So you object to the Secretary of State direct, not to the acquiring authority. And then, as I said before, if there is or if there are objections which are not withdrawn, then the Secretary of State will require the PINs to carry out a public inquiry. So we've got a degree of time between the objection period and the inquiry to do as much as we possibly can to negotiate with all the people who objected, and of course to continue to negotiate with all those landowners who haven't objected, to try and acquire as much of the land as we can, and also to try and remove as many objections as we can, or address as many of the objections as we can. And next slide, please. So we have our inquiry. The inspector or the Secretary of State, as appropriate, will confirm, hopefully, our order. So then we have to write to everybody when we get that letter to say our order's been confirmed, and say this order's now been confirmed and it's ready to go. But there's also this 6-week legal challenge period during which someone can bring a legal challenge, not just to say, I don't like that decision, but because there is some legal issue with the decision. So we have a 6-week window. If nobody does make a legal challenge in that 6-week window, we are then safe from further legal challenges. We can serve our land acquisition notices. So although you could serve land acquisition notices during the 6-week legal challenge, it is risky for obvious reasons. If you then get a legal challenge and your order ultimately is quashed, then you've got a problem because you may have taken possession of someone's land effectively unlawfully. So we tend not to serve the notices during the 6-week period, but we use that period to prepare the notices. So that'll be refreshing our land referencing, our land ownership checks, to make sure that we identify correctly all the people who need to receive a notice, and we can start printing them up and getting ready to go. And then once we've served our land acquisition notices, they generally take about 3 months for us, or a minimum of 3 months, for us to be able to take possession of the land, move on to the land and start building our scheme. As I said before, the great thing about compulsory purchase is that once you're on the land through a compulsory purchase, if you haven't agreed with compensation already, then of course you can do that. It's effectively offline, if you like. You can carry on with your scheme, carry on with your development while you're settling the negotiations for compensation. You don't have to wait until every single one's finished before you can get onto the land. So we settle our compensation. So to give you a very broad idea of how long the process takes, it's normally, from what I've said there, from resolution to CPO. So the resolution is the formal decision to use compulsory purchase powers. So from that point, until the CPO is confirmed, we've got between about 9 to 18 months, broadly speaking. It will depend on the size of the project and various things. And then once we've got our CPO, to actually get onto the land will take about 4 or 5 months. That's because we've got our 3-month notice period, plus our 6 weeks challenge period, plus a week or so to actually get the notices out in the post and what have you. And then we've got the logistics of actually taking possession of the land after that. So that's a very broad overview of the CPO process. Mike's going to talk to us now about how we make the case to justify our compulsory purchase powers.
Can we have the next? Thank you. I just want to start by running through what we should include in order. And there's 2 different views. You put everything in at the beginning, or you try and acquire everything and put the last interest in you can't acquire. I tend to go for the first. It tends to mean that you've got a more consistent project program, and tends to mean you're not sort of targeting the few people who are left, but there's always a sort of project specific solution. So there isn't a general rule. And sort of taking the theme of the, I suppose, the balance, let's move on to justifying the order on the next slide, please. With any order, you've always got to factor the balance in. If you think about the legal system we have in the UK, usually when something has someone taken from them, they've done something wrong. Whereas with compulsory purchase, the only thing they've done wrong is be in the wrong place. So there really has to be very clear public benefits. There has to be specific legislation that enables that. And the key thing to think of here is proportionate. Proportionality is the impact proportional to the need, to the loss. And in guiding that, we have guidance from government. So if we jump onto the next slide, please, we have what is certainly will get you to sleep if you're struggling to sleep is the government guidance, which is really the manual. Any local authorities proposing to use CPO powers need to be aware of this, should read it, or failing that, should get the team that knows what this is, how to use it, and run the project in light of it. So that really is, I suppose, the critical Bible for assembling sites with statutory powers. And if we jump onto the next slide, I think the key lesson to come out of this is the compelling case in the public interest. This is a common set of words and themes that runs through site assembly. There really has this very, very compelling argument that the public interest is greater than the individual loss. And it is that balancing judgment that the minister, the inspector has to take, and any authority promoting these should have that in their mind from the very, very beginning to make sure the case is as strong as possible. So if we jump onto the next slide, please. In this slide and the next slide, I've given a bit of a summary of the wording around the key tests in the guidance. I won't go through those now. I've got some more slides on those, but they're sort of in there for the slide pack to save you reading the specific bits of the guidance. So if we jump on to slide 29, which is next but one, please. The next one. So one of the key things from the guidance is policy support. There really needs to be adopted or strongly or emerging policy with significant weight, which is supports the scheme. Now that can cause a problem if you've got a scheme which has been approved on the basis of material considerations and there isn't policy support for. So you really need to think about that at the beginning of the project. How do you put this policy in place? So when you're taking a new scheme or a large area of a town that doesn't work, at the very beginning, you might start to look, well, do we have the planning policy? If not, what are we trying to do? What are we trying to achieve? And how do we put that policy in place? There are certain schemes where that might be less important. You know, dangerous building demolitions is a clear example that falls into that. If we jump onto the next slide, the next test in the guidance is well-being, which I suppose is a slightly nebulous concept, really, but it's vital to that compelling interest test, that you have to really show these well-being benefits. You don't have to show environmental, economic, and social. Environmental, social, and economic. But if you can show them all, it is better. One will be enough, but the greater those well-being benefits you can demonstrate, the stronger the case for confirmation of the order. Can we jump into the next slide, please? And alternatives is another test. The clearest example of alternatives is a different scheme, a different solution. They can be quite easy to rebut sometimes. Design tweaks is probably the most challenging one. You've come up with a scheme, but actually could have a slight different iteration of that scheme or part of that scheme that might have a lesser impact on some party, but deliver the same outcome. So really don't underestimate number 3. That's probably where you'll have most problems. So let's jump on to the next slide, please. And this is effectively deliverability and delivery structures. That any project needs to be deliverable. Doesn't have to be financially viable, but if it isn't financially viable, you have to show how it can be achieved. And of course, there isn't really a perfect delivery strategy. Any delivery strategy is a bit of a sort of hash of different options, really. The more reward some party wants, the greater the risk will be to get that reward. And local authorities have a different risk profile to some developers, different risk profile. So any delivery strategy will ultimately be a compromise between the promoter and also their delivery partner if they want to bring in a suitable delivery partner. But having that delivery structure there and be able to demonstrate the delivery is key part of making sure the test in the government guidance is satisfied. So can we jump onto the next slide, please? So in terms of bringing that delivery partner on board, you'll almost certainly have to go through some form of public procurement process. There may be certain exemptions, such as a party has a significant land holding, but more than likely you'll want to procure a partner through a transparent and open process. You'll set out certain criteria that they have to meet, which reflect the outcomes you're trying to seek.
So in terms of delivery partners, I think Mike's probably covered it there. Make sure that you've got a partner you can get on with and that you're aligned on what you're trying to achieve. Those are obviously the key issues. Go to the next slide, please. So Mike's talked about making the case and delivering the project. One of the important things which is stressed in the guidance and also relevant to some of the recent decisions that we've seen as well on CPOs is negotiations and engagement. So negotiations to acquire by agreement must run across the entire CPO programme, before the CPO programme really. When we start thinking about land assembly, we need to start off with our negotiations and run that right the way through while we're doing the negotiations, while we're doing the objections, in the inquiry, after the inquiry, and even while we're up into our compulsory purchase powers are commenced. So you can have the next slide, please. So why do we need to undertake reasonable attempts to acquire by agreement, and why should we not just jump straight in with our CPO? Well, it's set out quite clearly in the guidance that we've seen already from DLUC on how they expect the acquiring authorities to put their compelling case forward, and it's demonstrating that you've made efforts to acquire the land by agreement and not relied on the CPO as a first port of call is very important, and it's stressed throughout that guidance. But also the guidance which is aimed at the landowners, which is set out on the DLUC website. These are a set of guides or booklets, as used to be called, which explains to landowners in, well, fairly lay terms, but not condescending terms, understandable way to understand what your rights are, what the CPO process is, how it's going to affect you, and what your compensation entitlement is. That should give people some visibility on what it is that's being thrust upon them, so to speak. And you'll see there a couple of extracts where it says quite clearly that the acquiring authority is supposed to be acquiring by agreement wherever they possibly can. Go to the next slide, please. Similarly, this is a manual that's published in Wales, but it's still a lot of good advice for those practicing in England as well. Again, aimed at acquiring authorities rather than landowners as such. But again, there, a couple of things where it's saying straightforwardly, CPO should be a last resort, as they call it, and we should be using negotiation whenever we possibly can. Go to the next slide, please. So I'm going to look in this section about what the guidance and the onus is on us trying to reach agreement if we possibly can. And that's a very, very strongly, as we've seen already, the recommended approach from all the government guidance. Who should we be engaging with, and who should we be serving our notices on when we make the order and when the order is confirmed? And some common practical issues to think about in making sure that we engage effectively and get the best result we can from our engagements and negotiations. And then what happens if we don't get it right and our engagement and evidence it shows that we haven't been taking acquisition negotiations as seriously as we should have done. Go to the next slide, please. So who must we engage with and serve notice on? We must serve notice on all affected owners, lessees and tenants. Anyone who would receive a notice to treat if the land in the order was acquired that way. There are a couple of ways we can actually acquire land under a CPO. We're not going to get into that today. But basically, anybody who would require a legal notice if we exercised our CPO, they should be brought into the discussions, our engagement and our negotiations. And anyone who's likely to have what we call a Section 10 of the Compulsory Purchase Act 1965 injurious affection claim. So that's a technical way of saying anyone who's got not rights, not land acquired from them, but rights that they have over land which might be acquired and which will then be disrupted. So it might be a right of way or a restrictive covenant or something which will be affected by the scheme, even though they're not having any land taken from them specifically. So all those people are the people that we should be dealing with in terms of our negotiations, our engagement, and certainly in terms of our legal notices. In addition, when we're serving our legal notices of making our CPO and its confirmation later in the process, we need to attach copies of the notices to the land in prominent positions, and we also need to publish notices in the local newspaper for 2 weeks. And anyone who receives a formal notice should also receive a copy of the statement of reason, which is setting out what our justification for the order is. Go to the next slide, please. So these are some of the things that the guidance says, the DLUC guidance says that we should consider doing. So when it says you should consider doing these various things, you should actually be very, very prepared in the inquiry to say why you didn't do those things if you didn't do them. So what sort of things should we be doing? Well, firstly, providing clarity on what the compulsory purchase process involves, basically keeping people informed as to what CPO means, what it means for them, what the impacts are, what their rights are, and also when things are likely to happen as well. And that might be a changeable feast in a lot of projects, but we should try and give people some sort of an idea of when the land is expected to be taken, when the inquiries is expected to be, when they have to make certain responses by, and that sort of thing. And it needs to be in an accessible format. So we can send out booklets, we can send out letters, we can put things on our website, we can have public information events at the site that's going to be promoting the scheme and also giving information regarding land assembly and the compulsory purchase process. And CPO is a complex area, particularly for people who aren't engaged in the process on a regular basis and aren't maybe property professionals. They're just doing whatever their day job is, living their lives in peace. And then all along comes this compulsory purchase order and it's thrust upon them. So we need to make sure that we can get these messages across to people in a way that's going to engage them and properly inform them, not just blind them with a load of gobbledygook they can't understand. Next slide, please. Appointing a specific case manager during the preparatory stage. Well, that's a great one. Make sure that there's a name that people can get hold of. And you might have 4 or 5 of these, maybe divvied up by various areas or different types of occupiers. So one for residents, maybe one for businesses. But have someone that people can actually get hold of and talk to and ask questions of. And make it a single person so that people don't get passed around between the contractor and the surveyor and the council and the developer. And also, of course, the great thing about having a case manager is that you've got a central person sort of coordinating your approaches, because you are going to have to at some point demonstrate to the Secretary of State or the inspector that you have engaged efficiently and you have engaged people and taken their concerns seriously and negotiated to try and buy land by agreement. And if you've got 3 or 4 different teams all doing their own thing, trying to pull all that together to see, well, what bits have we missed? When did we have gaps? And if you're only finding that out when you're writing evidence to the inquiry, you're not going to have a very fun time at the inquiry. So coordinate your approaches early on and make sure that whoever's contacting landowners is talking to each other internally as well, so that you've got that record of what you've done that you can present to the inquiry and say, look, these are all the efforts we made, all the joined up efforts that we made to engage with people and negotiate for the land. And it says keep delay to a minimum. So when you're starting the CPO process, try and start at a point where you know you're going to have a degree of momentum and try and get it right, obviously, as it says there, so you don't have to go back and do it again. Nobody wants that to happen. Next slide, please. Offering to alleviate concerns about future compensation by entering into agreements Sometimes limited scope for that because we don't always know what the proper compensation is going to be, particularly if you've got leasehold interests. The market, as it is at the moment, is all over the place. We don't know, for example, if a business might be able to relocate. If they relocate, where will they relocate to? What sort of premises they're moving into? Could be all sorts of variables, but it's one of the things they suggest in the guidance. And more beneficial is offering advice and assistance to affected parties with respect to their relocation. So we should really be trying to engage people, helping them to find alternative options for premises, for businesses, for residents. Where can they go? What's realistic? And help them. And not only really helping people to deal with the CPO and helping them to get through the process, it also allows us to gain evidence so that if someone turns up at the inquiry and says, well, there's nowhere they can possibly go and no one's given me any assistance, we can say, well, look, we found these 3 or 4 properties which we think are perfectly okay, and someone's just refused to look at them or whatever it might be. That will strengthen your case quite a lot. Next one, please. Providing a not before date, this is the earliest date which you're going to acquire land. So it's not saying we're going to take it on this date, it's saying that we're not going to take it before this date. So we've got at least that amount of time to sort of prepare, if you like. It sounds like a good idea on paper, particularly in the terms of business relocations. I don't personally think it's such a great idea. What businesses need to know is when can I move? When do I plan my move? If they're saying, well, it might be sometime after 2023, then that's not a huge amount of use, really. But again, something to consider. And also give consideration to funding landowners' reasonable costs of negotiations. Very broad, but it's just giving people access to professional advice if they're obviously not having to dip into their own pocket to get it. The next slide, please. So what are the benefits in negotiation and engagement? Well, first of all, it builds good relationships and you get early notice of any issues that might arise. So you might have, for example, people who have particular needs for schooling for their children, for example, or you might have a business which has particular constraints. Maybe they've got other branches nearby they don't want to bump into. Maybe they've got particular skilled staff who can't move for whatever reason. So it's finding out all these things that you can then got a much more early notice, gives you a much better idea of being able to address those issues, reduce them or mitigate the impact. Because as Mike said, it's all a balancing act at the end of the day. What's the benefit? The compelling case of the CPO is going to be the benefits versus the impacts. You can either increase the benefits or you can reduce the impacts, or ideally do both. So engaging early allows you to understand what the impacts are and help to work towards mitigating them. And that's going to improve the balance of your arguments. Next slide, please. What happens if we don't do this? What happens if we get it wrong? Well, obviously, there's risks. So the more we alienate people or the less we bring people on board, it means the more objections we're going to get. That means more work at the inquiry, more risk at the inquiry, probably a longer inquiry. A longer inquiry is going to take longer to get into the diary, so you're going to extend your programme all the time. And of course, the less land we buy by agreement, the more land and landowners we have to deal with at the inquiry and also through the CPO process. And if, of course, in the worst case, if our CPO gets rejected, then obviously that's a big hit for the project. It's going to cost a lot of money to do it again. If we have to do it again, it might make us a very expensive land assembly process if we've got a failed CPO. And of course, it's going to have a massive impact on our project as well, on our programme as well.
Can we jump onto the next slide for my section, please? I think one thing I also just want to add on consultation is that I sort of see it as like being the elephant in the room, that the amount of times I've seen consultation where it's just providing information, whereas consultation really should provide an opportunity for people to effectively engage and potentially substantially change the proposals, whereas often it's just, we're going to tell you what's happening, which isn't really consultation. And keeping that in mind to me is quite important to effectively undertaking that duty reasonably. And we have another duty here which all public authorities have to abide by, which is Section 149 of the Equality Act 2010. And this is generally known as a public sector equality duty. Now, it is something which has to be discharged as part of any decision-making process. And if it isn't discharged properly, it's a basis of challenge to the scheme, to the planning permission, to the CPO. So it's really important to get this right. So we really have to look at any potential disproportionate impacts on groups with protected characteristics. This doesn't mean go out there and identify everybody who's got a specific protected characteristic. It means effectively look at the potential impacts, assess those impacts, see what mitigations are there, though you don't actually specifically have to have mitigations. You have to consider the impact, and in some cases impacts might be disproportionate, but on balance you might consider that's appropriate. So that's generally done by virtue of a qualities impact assessment, but that alone isn't really sufficient. This needs to be something that's embedded into that whole project process. So I tend to prefer that the EQIA is really kept as a draft document and is in a working document that records this as the life of the project continues, and then ensures that duty is discharged as that project life cycle continues. So that one is a really, really important one. Do not forget that one, or you are liable to an easy challenge. So can we jump onto the next slide, please? Slightly different topic, but again, I suppose a major problem is special kinds of land. Not all land can be compulsory purchased. Some simply can't, like Crown land. Some of the special protections like open space or statutory undertakers land, or special processes you've got to go through to acquire or replace it with things like allotments or common land, and special consenting procedures which apply to this. So it's really, really important to identify these designations early on, to come up with an appropriate strategy to mitigate those problems. In some cases, that may involve doing things by agreement. We know statutory undertakers getting that agreement over the line really early on, entering into a protective provisions agreement to make sure that their infrastructure isn't harmed, but make sure your project can happen. But picking up that early is vital. You don't want to get to an inquiry and find you've missed some open space in there. It might sound minor, but it might mean your scheme CPO is effectively going to fail. So don't forget those, small but important. Can we jump onto the next slide, please? And that brings us on to the inquiry and the inspector. Most CPOs, there's someone hopeful that there's not going to be objections and there's not going to be an inquiry. And I've seen that in cases where they've had a whole team or individuals in the team convinced there's going to be no objections, then you end up with 100 and odd objections. In practice, start on the assumption you're going to have an inquiry. Start on the assumption there's going to be an inspector who examines this. And that inspector is someone who is independent, should effectively be apolitical, should determine, the merits of the argument and the merits of the objector's argument to come up with a balanced position. But start on the assumption this is going to happen. Start on the assumption that anything you prepare could end up in front of the inspector through either intent or through freedom of information type requests. And if you start from that position, you'll be in a much, much better place. It's also important to remember that most CPOs are confirmed. Some are not, but most are. And mostly if you get the case right and you have a very strong argument, you're likely to get, or more than likely than not, to get your CPO. And also your cost of the inquiry, the cost of getting that CPO and the length of time is probably proportionate to the level of complexity in the case, the scheme, the level of opposition. So if you've got a fairly uncontentious scheme where you've got one or two landowners, you might have a day or two in public inquiry. If you've got something which is much more contentious, you've got a typical one for a social housing estate renewal scheme, you can probably expect to spend 2 weeks in inquiry or something like that to deal with those issues. If you have an inspector who runs it efficiently, it will probably condense the programme because they won't permit objectors to keep covering the same ground repeatedly. But you don't really know what you're going to get until you get there. But you should definitely plan for having that. So can we jump onto the next slide, please? So we've got decisions here. So decisions, to read them, it's about as dull as looking at these pictures of broccoli artwork we've got to the right. But they are all slightly different, just like those pictures. And key decisions which have been where CPOs have been not approved are key ones to look as lessons. So the most recent cases we've got which are relevant here are the Vicarage Field case, Nicholson Centre in Maidenhead. That is a very recent decision. I suspect we're probably going to get a judicial review on that one, which will be quite nice if we get a JR on that. The arguments raised there was essentially sort of lack of substantive negotiations, loss of a nightclub, compensation not making that loss good. It strikes me that we will get a JR, but we don't know. We'll have to wait and see, and watch. Aylesbury, that was a few years ago. The public sector equality duty was a key topic there. that decision was overturned. There was a subsequent second public inquiry, and the CPO was confirmed after that. But a lot of important lessons were learned from that case. So these are cases that are worth reviewing, worth reading some of the lawyers' articles on these, maybe a selection of them, because some of the lawyers' articles aren't necessarily right. They don't necessarily have all of the picture, but they give you a good feel for decision making. So let's jump on to the next slide, please. And I think, Paul, we're back to you.
Thanks, Mike. Yep, just a couple of tips and tricks from me, then a couple more from Mike, and I think we're almost done. We are marginally over our time so far. So in terms of my tips and tricks, the compensation duty, bear in mind that our duty under the law is to pay the right amount of compensation, not the lowest amount we can get away with. Now, I think that's well understood generally, but sometimes it can be under a little bit of pressure, particularly if the scheme is struggling with viability. The other thing to bear in mind is sometimes, and it is rare, but sometimes compensation might not be the entire answer. So particularly where you're doing estate regeneration schemes, and we've seen this in London, particularly where prices can be quite dramatically different from street to street. People, even if you give them a fair market price and the availability of accommodation they can afford outside of the estate isn't there. So shared equity, for example, might be a way forward to make replacement premises more affordable. Negotiations and engagement, well, we talked about this at a bit of length. Start early and be effective, and also coordinated across the project team. How things are presented is just as important as what is presented, but certainly you need to have a record of what you've done to negotiate with everybody and to engage people. You will get people at inquiry on a regular basis saying, I've not had any engagement whatsoever, despite the fact there's reams and reams of stuff. But if you can't prove that you've done that, then of course, who's suspect they're going to believe? Who's going to give the benefit of the doubt, usually, to the claimant. Sorry, not claimant, the landowner. And then finally, strong policy support and resolve impediments, planning in particular, but other impediments also just as important. Ensure the case for confirmation of the order is as robust as you possibly can get it, particularly in respect of planning. If you're doing a CPO, which is under the Town and Country Planning Act, you have to show that it fits in with the planning policy. And of course, you have to do the same thing for most others as well, but it's a particular point in the 1990 Act. One way of doing that, of course, is to get a planning permission. But of course, getting a planning permission and getting a CPO are probably two of the longer term things in the programme. And it's how those two overlap that can be the cause of many meetings on how can we compress our programme. And you can overlap the two with a degree of risk, but be mindful of what you're trying to achieve at the end of the day. Mike, your tips and tricks.
Yeah, coming on the next slide, please. So the first is commitment to delivering a track record of delivery, that you really need to demonstrate the project is deliverable, and a clear way to do that is to have a delivery partner with that track record. So when you're procuring a partner, bear that in mind. If you're a council looking to self-deliver, if you haven't self-delivered before, you're probably going to struggle to demonstrate that. You probably want to pick some easier self-delivery projects and show that you can step up, or you will need to bring in a contractor who's got that experience, etc., and do it as a sort of design build type of contractor arrangement. But really clearly showing that's really, really important. Once you've got that partner on board, you might want to review whether that partner's capable of doing it, get a sort of third party critical friend review, so that when you're in inquiry, you can say, you know, we've had it looked at. Not only are they saying they'll deliver it, but we've had someone check and we think they'll deliver that. So the next one is partnership related again. Remember, your partnership is more than just a legal agreement. If you've got to the point of saying, you know, line 16, 7, 10 of schedule 50,000 of the agreement says you'll do this, you're probably not working as a team. You want to work as a team, get that project set up so you have the right culture between the team, but also bear in mind that there's different statutory functions and objectives of the developer and of a council. You know, a council has a number of different statutory hats anyway, the planning authority, highway authority, etc. Developer will be there to make money, but you can merge these objectives. You know, both are probably trying to provide a great place. You know, great place is also a place of great value. So you can merge those objectives of the developer to make money and the council or public authority to make a great place, and merging those objectives while being mindful of those clashes is really, really important, just to get that team culture right at the beginning. So that's everything from me. If you want to wrap up, Paul.
So I think, yeah, we've slightly overstepped the mark in terms of our chit chat. We've got plenty of questions to get through. There are a few key lessons and conclusions here. Strong policy support is always a plus. Most CPOs are confirmed, but significant time and resources are invested to ensure the promoter's case is as strong as possible. CPO doesn't have to be complicated or expensive, particularly on the smaller schemes. It doesn't even have to be particularly long in terms of the programme, but do make sure that you don't assume your CPO is going to be authorised or confirmed. Make sure you follow the guidance, engage properly, negotiate for the land, and you should be okay. Make sure you've got a strong, compelling case without any impediments to the scheme. Substantial opponents to acquire land by agreement. We've done that engagement and take advice early on. Claire.
So thank you very much, gentlemen. So we're now going to move on to some questions and then we'll do a final wrap up. So Paul and Mike, if I could ask you both to come back onto camera, and I'm going to fire some of the more popular questions at you. I suspect you'll know exactly which type they're going to be. So the first one is quite straightforward. Is there a tax advantage for some owners to wait for a CPO rather than try and agree a deal beforehand?
Short answer is yes. But sometimes, I mean, it depends obviously on the person's tax position. Where it normally can make a difference is capital gains tax rollover. Now, I wouldn't pretend to be an expert in that area, and it will again be very sensitive to the particular landowner's position. But even in a situation like that, if it's a larger scheme and you've got plenty of people you need to CPO, there's no reason why you can't reach agreement and say, there's our agreement. We'll exercise the powers officially just so you can get your tax benefits, but we agree the deal ahead. And then, of course, they won't object. There's no problem. So it doesn't mean you can't engage with somebody in a situation like that. It just means that you might have to go through the motions on a CPO as well.
Okay. I'm just going to say it has been relatively flexible as revenue in agreeing that. So for some projects I've seen, the acquiring authority go and agree that in advance where the number of people have had those issues. So basically go and get tax advice and potentially get your tax advisor to approach HMRC.
Okay, I was going to say I was going to rattle through because we've had so many questions. Unfortunately, there's no way we'll get through them all. But another popular one: can you move ahead with a CPO even if compensation has not been agreed? Is it possible to acquire and start development while the process is being followed? I know we've kind of answered that through the presentation, but did you want to sort of add any more to that, either of you?
I think the answer is yes. It didn't used to be the case, and that was just so the historic railway 19th century stuff used to have to be agreed. So, and one of the key reasons it was changed was that would delay projects. So generally, yes, compensation might actually be agreed years later, and someone might get statutory interest on that, which isn't particularly great, which can provide an incentive to reach agreement. The whole process is intended to really separate the monetary issue from the land and getting on with the project.
So another favourite topic that always comes up, ransom strips. So are CPO powers permissible to use to overcome ransom strips of land to ensure developments can come forward, where the adjoining site is the site where transport infrastructure exists and is to be the link through?
Ooh.
You thought you might like that one, Paul?
Well, that's touched on a number of little sore points. But before we get to the transport facilitation point, which is a specific one, just generally, yes, of course, you can use a CPO where there's a ransom strip, and it's usually a great way, particularly if the landowner has got unrealistic expectations as to what that ransom is worth. What a CPO in those situations might not do is give you a get out of jail free card in terms of paying a ransom. So in very broad terms, compulsory purchase compensation disregards any impact from the scheme. So if the ransom is due to your particular scheme and you couldn't have got that ransom if it hadn't have been for a CPO or other statutory powers. So for example, if you've got something that's in the way of HS2, and you can say, oh, well, I've got a ransom because if you don't sell, you've got to go around me. Well, you know, if you take HS2 and a compulsory purchase powers and the statutory powers away, then obviously that ransom vanishes. If you've got a regen scheme in the middle of a town centre, you might find that there's a particular scheme being promoted by a developer with support under a CPO, which might not have got off the ground without a CPO. You can't take account of that ransom. But there may have been a smaller scheme which could have come ahead without a CPO, and there may have been a marriage value or a ransom value attached to that, which you could claim for compensation. So yeah, it's not a get out of jail free card in every sense, but if the ransom is due to your scheme, you can avoid paying that. Just touching very briefly on this transport facility, if you've got a transport scheme which was facilitating development, there are new powers been brought in, or new rules rather been brought in on the no scheme world. The whole thing was revamped in 2017, and there are some very complex bits aimed particularly at TfL and GLA, as to whereby if you've got certain things where a scheme facilitates another regeneration and there's a CPO for a regeneration later on, which is facilitated by the scheme. So for example, Crossrail comes in and you get a CPO to do a regen scheme on the back of the Crossrail, then you can disregard not just the CPO scheme for the regen, but also disregard Crossrail as well, just as an example. But it's quite complex rules all around that.
I think the notice take professional advice on that one.
Yeah.
And Mike, did another sort of hang-on question is how we deal with unregistered land in regards to CPO?
I mean, registration or ownership doesn't really matter. It may be referenced slightly differently. I mean, I've seen this question a few times, that we've got not necessarily unregistered land, well, probably unregistered, but definitely unknown ownership land. You can't find the owner. If you can't find the owner, you can't negotiate with anybody. The only way to acquire it is basically to get that CPO to deal with it. But then if you've got no owner, you're probably not going to have any objections to that. So it's stupid not to use those powers to cleanse the title to ensure you have that interest. So basically, the CPO allows you to acquire that interest, to then register that interest through the title you take and resolve all of those historic issues.
Great. Now here's an interesting one. So can CPO be used to acquire land from a house builder who's failed to bring forward a residential development, thus enabling the LPA to gain control and assist delivery?
I've been there, not done that. Mm-hmm. So I mentioned in the presentation, I think I mentioned a scheme in Northampton a few years ago now, and I was actually representing one of the house builders. So this was a site in Northampton, 3 different landowners. One was the legacy owner of part of the land, and the other 2 were house builders, and they had about half a site each. And down the middle of it was a CPO, unregistered or unknown ownership plot. And originally, the acquiring authority had said, I'll CPO the unknown ownership land, and then you can get on with the scheme, and everyone was happy. Everyone was happy and over the moon. There was a fair bit of messing about, to be fair, between all the various partners, and they hadn't made the progress that the Development Corporation, as it was, wanted to see. The Development Corporation's life was ticking away. They had about 2 years left, I think. So then they turned around and said, you know what, we're just going to CPO the whole damn lot of it, and we'll deliver it. Of course, my client then rang me and said, I've got a bit of a CPO problem, can you help me out? So we put in an argument to say that we were, developers, track record, we had planning permission and everything else, and the acquiring authority at that time were probably about 18 months to 2 years behind us in terms of delivery. So our basic case was, you can't deliver this scheme and as quick as we can. And if you facilitate this little bit in the middle, like you said you would originally, then we can get on and do the job. And that was our case. As it turned out, as I said, we did a deal at the inquiry, and everyone was happy in the end. But I think it's very difficult for you to go to a developer and say, or to CPO a developer and say, you haven't delivered the scheme, we're going to do it better. If that's a developer who's got a proven track record, I mean, it's a national house builder I was dealing with. So yes, it's possible, but you'd have to have a very good case, and you'd have to have good evidence that the developer hadn't actually delivered the goods, and that they couldn't deliver the goods going forward, and that you could do it better. Those are the 2 key questions, I think. But yeah,
I think to add to that as well.
Sorry.
I think to add to that as well, the person wanting the CPO is essentially presumably wanting that development to be delivered. So even if the CPO isn't successful or effectively is withdrawn, on the basis the developer is going to deliver, it may well expedite that developer delivering, which is achieving what you're wanting. So it's potentially looking at these statutory powers, not just from the perspective I'm going to make and get a CPO, but it's using them to bring things forward, potentially with expectation. You won't get to the point of having to get to an argument in inquiry.
And we know that
exactly
the
right.
inspectors are very keen at looking at deliverability at the moment, and with orders not being made, that's something to bear in mind.
Yes.
So one for you, perhaps, Mike, more than Paul. So how crucial is planning permission to the success of a CPO, noting the level of risk for a developer to commit monies and work to a site that's not fully assembled?
I mean, we're probably talking here about a planning act, as in Town and Country Planning Act, CPO, and it's very important. With infrastructure schemes, less so, because you get the planning permission with it. But if you're going down the Town and Country Planning route, it was unlikely you'd have a barrister that would recommend you getting to inquiry without having either a planning permission granted past the challenge period or been very close to that point. It just gives you much more certainty over that. That's the position you want to be in. It means you're not dealing with planning arguments at an inquiry as well. You know, we're looking here at the practicalities of making one's life easier and making the confirmation of the order case much stronger.
And one for both of you, feel free, Paul. How would you deal with claimants for compensation who argue that they are the owners by adverse possession?
Well,
There might be a short conversation, I suspect.
If they can prove it, then they are the landowner. As simple as that. So, in fact, we've got a case on at the moment where exactly that's happened. So, someone's got adverse possession of a piece of land which is required for a development, and we're looking at doing a CPO potentially for buy it back off them.
So essentially, it's all about the proof, isn't it?
Yeah, absolutely.
Yeah, the argument there is worth mentioning is if they may only have possessory title rather than title absolute, so there may still be a difference in compensation terms if you're talking about development sites. So you just still think about the level of detail around the nature of interest they've acquired.
So
yeah,
his
prospect of possessory title is a different thing to actually having possessory title.
Exactly.
But once you've got possessory title, that can have an impact for financing a project, because there's a difference between possessory title and absolute title and how the land registry references it. So I know a developer that's had to go and get indemnity insurance for that, or because they had very difficult issue in financing it. So it gets some specialist legal and potentially financing advice at that point if it's a big one.
And a very different question: how is well-being normally evidenced?
Yeah, well,
they're throwing some good questions at you today, aren't they?
Well, it's social, economic, in terms of the 1990 Town and Country Planning Act, is social, economic and environmental well-being. So the way you would normally evidence that in a statement of reasons, for example, it can be very similar actually to the ways that you would evidence it in a planning application. Obviously, the tests are different. So you need a much better case to get to secure a CPO than you do to secure a planning application or planning consent, but the principles are the same in terms of meeting. What's the need? Look at the planning policy to what the need is. Are you providing the answer in a compliant way with what the planning policy says?
Mike, do you want to add anything to that?
No, I'll leave it at that.
Okay.
Well-being, slightly nebulous concept. We can bore everybody to death with it, I think.
Okay. So is local plan policy or allocation necessary? What about projects related to government-backed regenerations, such as the town deal and high street schemes?
It's in the government guidance, the wording fits with the local plan or emerging local plan. You really do want that policy support in there. If you haven't got that emerging policy support, you've probably got a problem. I suppose it might be different if you've got a very small scheme that doesn't feel like it needs specific policy support. You've got a standalone building in an area, but if you're taking a large scheme that has a large impact, you really do want clear policy support for it. And ideally that policy support will also endorse using compulsory purchase. It's SPDs. The better ones for these schemes will have a specific delivery page in them, which will set out using those powers and a policy basis for the powers.
Of course, that's entirely true for the 1990 Act powers, which are planning powers. Obviously, the Homes England powers are a little bit more circumspect. So, again, you still need to have a good, compelling case, but it may not be quite as dependent on planning permission as a 1990 Act one would. And also the Housing Act as well. we've advised clients where they didn't have planning permission for their replacement scheme, but they wanted to drop a building on a housing estate, and the Housing Act was much better, or much easier to make a case for that without having planning permission in place already. But yeah, if you're on the 1990 Town and Country Planning Act, which a lot of regen schemes will be, then yeah, exactly, you need to have your planning sorted out.
Well, gentlemen, I'm going to draw the Q&A to a close. So thank you for your time. You are now relieved. You can turn off your cameras and your microphones and go and have a strong coffee. So just to wrap up, can I just add that any of the advice that's been coming through in the chats from other attendees, obviously we have no sort of link to any of that advice. What we'd like to do now, if that's okay, is some take-home messages there on the screen that will be sent out to you. May I thank you for your time this afternoon. Hopefully you've all taken something away from it that is of benefit to you and your work. And thank you all for your time.